I'm Aryan Mandas, and I'm here to talk about patent protection for emerging technologies. We all know that emerging technologies such as AI, biotechnology, and blockchain technology have had a very rapid growth in the last 5 or 6 years. Artificial intelligence has started as a personal tool, but has rapidly evolved into corporate tools. For example, companies like Cognizant have partnerships with Microsoft to use Copilot for all of their code generating or other such issues. Patent law has traditionally been the primary tool for promoting innovation and for incentivizing companies to invest in R&D for innovation. But the growth in emerging technologies and the structure of emerging technologies has created a lot of challenges for patent laws. So our primary question is, can current patent law sustain in a world with emerging technologies? We all know what patents are. Patents are an exclusive right given to an inventor for 20 years to make, to use and to sell their invention. The primary tools, the primary global agreements that are in play are the WIPO-PCT agreement and the WTO TRIPS agreement. In India, the Indian Patent Act of 1970 is in play. And the challenges that currently are being faced by traditional patent laws. The emerging technologies are interdisciplinary technologies, which means they employ aspects of all fields of engineering, from software technologies to industrial production. However, patent laws have traditionally been only for industrial mechanical aspects or electrical aspects. Softwares have always had a very minor role to play when it comes to patents. In India, software patents are, as far as I know, are not eligible for patent protection. Biotechnology has raised ethical concerns over exclusivity to human DNA. How can I, as a company, own human DNA or parts of human DNA that are considered natural resources? There are a few case studies that I have observed. The Dallas case is pretty infamous. AI inventorship is a major concern. And US EPO and the full Federal Court of Australia has rejected the claims that AI can be an inventor, stating that national consent must be involved. However, South Africa has been a country that has passed this patent. This can also be credited to the fact that South Africa doesn't have a rigid system for defining what an inventor is. Software patentability is a concern in the case of Alice Corp versus CLS Bank. A computerized system was used for reducing risk in financial transactions, and this patent was later invalidated as just using a computer to automate a system that already existed was not considered an inventive step. Later, a two-step test was implemented, which is to see whether a patentable subject matter is relating to an abstract idea, and then to see whether human involvement has been enough to change that abstract idea into patentable subject matter. Even in India, we have seen cases like Novartis versus Union of India relating to biotechnology, and Monsanto versus New seeds relating to genetically modified seeds. To conclude, I would like to say that traditional patent laws must be changed and conferences and discussions must be held to clearly define, in the case of AI, what an inventor is. Can we provide inventorship to AI? And if we can provide inventorship to AI, who has the right to license those inventions? In the case of biotechnology, there is a ethical concern as well as a concern on whether or not we can patent genetic matter. In India, medical innovations are considered unpatentable, so that is also a thing that we have to consider. And international standardization on these matters should also be considered.
So there are few observations. One is biopic is not that much emerging technology. It has emerged a lot. It has progressed a lot. The other thing is you cannot flag this very thing that biomedical innovation or medical innovations are not patentable. They are pretty patentable. Okay. you can raise certain issues like gene patenting may be contentious, the other things may be contentious, but there is no blanket prohibition over the same. Okay? So this is a clarification.
I must have misspoke. I didn't mean that they are not patentable.
You made this statement which is so be cautious. I'm not alleging you or something. Second thing is from your slides how blockchain technology could protect the invention or innovation.
The first point that you raised, which was about biotechnology not being an emerging technology. The biotechnology has grown in the last few years, but things like CRISPR and gene editing are pretty
You
recent.
have not mentioned anything about the same CRISPR or gene editing.
In my article, I have mentioned CRISPR and gene editing.
It's okay. It's okay. What I'm trying to suggest is that when you make a statement, you must be thorough with that very process. That what is patentable and what is not patentable.
Just to add 2 points, as someone who worked on the Faraday-Delany case and the Monsanto case, Faraday-Delany is the case in India which lays down the patent for computer software. It's a 2019 decision of the Delhi High Court and a 2020 decision of the erstwhile Intellectual Property Appellate Court, which relates to Section 3K, which talks about when a computer can be granted an invention. And second, Monsanto has to be seen differently from an agri-biotech space. It was on an artificial DNA construct, the 3J case. Just 2 points, no comments, but just so that you can go a little deeper on this.
What's the last point?
About the blockchain.
Blockchain technology is traditionally very open source, and even in cryptocurrency and other such aspects that are using blockchain technology, the developers are not trying to patent their publications usually. It's very open source, and the community in large is.
Can you provide better protection through blockchain?
Blockchain technology is considered more. How do you say? Private.
You have covered so many issues. So in research we try to focus on micro issue. So you take a caution rather than I'm not. I appreciate your efforts, but you must be focused a little bit more. Okay?
My input is exactly that. Frame a narrower problem. It will be easier to solve.
Yes.
Thank you, audience.